Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who is addicted to shoplifting. Let's see here. My wife has no need to steal items from stores, but she does. She has already been arrested twice for that crime. This weekend she was arrested again. Okay. First of all, if you take something from a store with the intent to permanently deprive the owner of that property, that is obviously a larceny. If the value of the property is under $950, it would be a petty theft under Penal Code Section 484. It's a misdemeanor which carries up to 6 months in the county jail, plus of a fine of $1,000. Now, if the value of the item or items is of $950 or more, then it would be a felony under Penal Code Section 487 that carries up to 3 years state prison, believe it or not. Now, here's the problem. It says right here that she already has 2 cases and another one. Well, if somebody were to commit 2 petty thefts within 10 years here in the state of California, at the discretion of the DA, they could actually file a felony for that petty theft. Even though it's a petty theft, they could file a felony version of that crime, which would carry up to 3 years state prison. So in a situation like this, if your wife has this compulsion or impulse, it will be very, very, very important. It will be very, very, very important to get her psychological help. She needs to get counseling, and it's going to be necessary to submit proof of this to the DA's office, because that would be her best shot to getting a felony reduced to a misdemeanor, so that it doesn't affect her ability to be able to vote or to be able to own a firearm down the line. And also, the other thing that needs to be understood is that if your wife is not a U.S. citizen, this type of offense is considered a crime of moral turpitude, which means in the future it could potentially result in deportation, exclusion from the United States, or denial of naturalization. Now, normally in a petty theft case, the DA's office is going to have to prove the intent of the suspect or the defendant. But in this case, it shouldn't be that difficult for them to show, especially considering that she already has these 2 priors. Hopefully your wife didn't say anything to the security or to the police when they finally got a hold of her, but if she did give a statement and did admit to it, well, then it's definitely going to be time to buckle down on doing those counseling sessions in order to avoid a felony going on her record, because repeated offenses become felonies for petty thefts. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who is having contact with a witness via video. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.